The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. The first case will be 20-1094, Soderberg versus Carrion. Mr. Riley?
Thank you. Good afternoon. May it please the court. Nicholas Riley on behalf of the plaintiff appellants.
Good to have you with us, Mr. Riley.
Thank
Welcome
you.
to the Fourth Circuit.
Thank you very much. In Cox Broadcasting, the Supreme Court articulated a basic First Amendment rule. It said, quote, once true information is disclosed in public court documents open to public inspection, the press cannot be sanctioned for publishing it, end quote. That's the situation we're in here, and that's the rule that governs the outcome of this case. Maryland court officials disclosed several publicly available court recordings to plaintiffs, and for that reason, they cannot sanction plaintiffs for disseminating those recordings. Now, the state urges this court to apply a more relaxed standard here. It argues that the statute at issue in this case, Section 1201 of Maryland's Criminal Procedure Code, should be subject to intermediate scrutiny as a time, place, and manner restriction. As we've explained, that's the wrong analytical framework to apply here, and I'm happy to speak more about that. But just as a starting point, even if this court were to analyze Section 1201 under intermediate scrutiny, as the state urges, the statute would still fail as applied to the dissemination of publicly released court recordings.
Counsel, this is interesting. Can I just ask a clarifying question here at the beginning? You're talking about publicly available recordings or publicly released. Are you including the video recordings in that characterization? My understanding of the rules is that they're governed a little bit differently, and they're not necessarily given to the public the way that the audio recordings are.
That's correct, Judge Rushing. And I am talking about both the audio and the video. The reason why the difference in the Maryland rules as to access to video and audio doesn't matter for the purposes of Daily Mail and Cox Broadcasting is because that principle, that right to disseminate, applies to all documents that have been lawfully acquired, not just to documents that the public has a right of access to, right? And so we know that from any number of cases, but Bartnicki illustrates that point, I think, quite clearly. Sure, obviously there was no public right of access to an illegally intercepted phone call, but once the broadcaster in that case, the radio station, had obtained that recording lawfully, it became subject to the Daily Mail principle. And that's the same with this court's decision in Ostergren just about 10 years ago with Social Security numbers. Obviously, there was the individual in that case had no right to other people's Social Security numbers. But of course, once they had been disclosed, once she was able to obtain them lawfully, she had a right to disseminate them. And so in this case, our plaintiffs obtained that video recording the same way they obtained the audio recordings, which is from the courthouse itself. It may have been a mistake on the clerk's part or on the court reporter's office's part, whoever it may be. It may have been a mistake to release it, but once they released it, it becomes subject to the same rule.
Can I ask you a question? This is Judge Harris, a similar threshold question. I understand that your claim is limited, as you just said, to the right to broadcast information that the government has already made available. But does it matter that your clients were actually given copies? Would this rule not apply if Maryland allowed in-court inspection of these recordings? Like you could come into the courthouse, you could listen to the recording, but they weren't going to give you a copy to take home with you. Would that be a different case?
Yes, I think that would be a very different case, right? Okay. Yeah, the issue here really does turn on the fact that they obtained these copies lawfully. As I mentioned in response to Judge Rushing's question, that's the critical distinction. That's where the Daily Mail Cox Broadcasting rule kicks in. And again, that would be true even if they didn't obtain them under a Maryland law. I'm sorry, go ahead.
And you're saying that that make a difference if they get them by mistake also, right?
That's exactly right, as long as they obtained it lawfully.
If the clerk makes a mistake and turns them over. So you'd say that the grand jury material, if it's given over by mistake, that can be published as well.
That's right. And I believe this court said as much in the Charlotte Observer case from 1990, which we cite in our brief, that I think they applied. I don't think they framed it as the Daily Mail rule, but they referred to it as kind of the cat out of the bag principle. I think they may have even used that term, but that's exactly right, Judge King. I'm happy to speak about why, as I was alluding to earlier, why even under intermediate scrutiny, this statute still fails, because I think that's an important point. And it comes down to this, right? The state's entire argument for applying...
I'm sorry, before you move on to your...
Sure.
This is Judge Harris again. Before you move on to your, what I take it as sort of your fallback argument, I just would like you to address what I understand to be sort of the state argument for why this isn't a Daily Mail problem. And that is because nothing about this rule would bar your clients from describing all the information that is contained within the recording. It's only airing the recording that's barred, whereas in the Daily Mail line of cases, you couldn't identify the rape victim or the juvenile in any way. It was sort of a prohibition on releasing the information broadly. Why is that wrong?
Sure. So I think that's wrong for a couple of reasons. One doctrinal and one just factual. I'll start with the doctrinal reason. The doctrinal reason is just, I think that's not quite what their characterization of when the Daily Mail rule applies, I think is just wrong. So when you look at Daily Mail itself, the prohibition didn't actually ban the dissemination of that information in any form. And in fact, it only banned its publication of, in that case, it was the juvenile offender's name. It only banned that dissemination in newspapers. And in fact, there were 3 radio stations that had disclosed the same information over the air that were not subject to punishment under that statute. So it's not quite, I think, as simple as, and that was also true in Florida Star, I should say, where it was a limited ban on a certain type of publication. But setting that aside, the factual reason why I think that characterization is wrong, that equivalence between a reenactment and a recording, or a description and recording, is that it's a night and day difference. And we know that in various ways, but one in particular relevant to this court is we've structured our entire appellate review system around the idea that there's a difference between hearing someone's voice, actual voice, the tone, the inflection they use, et cetera, and reading a transcript of what they say or reading a description. That's the reason why appellate courts defer to fact finders, trial courts' assessments of credibility and the like, right? There's differences in tone, inflection, emotion, pauses. All of that's critically important. It's the same reason why, obviously, we're talking here about the First Amendment right to disseminate, but in the First Amendment right of access context, we know that the right of access applies both to the live proceeding and to transcripts after the fact. The Supreme Court has been quite clear that simply providing transcripts of a proceeding after the fact is still a violation of the First Amendment if you didn't allow people to see the live proceeding. And the reason for that, again, is that there is a difference between, again, hearing someone's voice and simply reading a transcript or description. It's also the same reason, just again, this common sense intuition, why when a newspaper obtains a recording of an elected official or a politician saying something scandalous, they don't hire actors to recreate the phone call. They play the court recording. They make that available. The last point on this that I would say, and this kind of bleeds into the point I was making earlier, is if they're right. I'm sorry, Judge Rushing, were you about to ask a question?
No.
Oh, okay. I'm sorry. I saw the light up. The last point I was going to make is let's just accept for a moment, just arguendo, that they're right, that a reenactment or a description is the same thing as the actual recording itself, right? As you noted, Judge Harris, that's their entire basis for trying to get out and away from the Daily Mail Cox broadcasting rule. If they're right about that those two things, reenactment and recording, are really totally equivalent, one-to-one, then there's no possible basis for satisfying intermediate scrutiny's narrow tailoring requirement, right? There'd be no reason to say that it's illegal to disseminate a recording of a court recording, but then to have 2 actors reenact the exact same court proceeding and disseminate it in the exact same manner, right? Over the air, over a podcast, on a website. If those 2 things really had identical communicative content, then what possible basis could there be for banning one form and not the other? So I think, again, that's just kind of going back to the original point I started with, which is that the only way to get to intermediate scrutiny here is to accept a proposition that, 1, we think is false, and 2, would inevitably lead to, the statute still falling under intermediate scrutiny.
So you say
this is my last question.
Right? I'm sorry. we were talking over each other. I was just going to have him.
Go ahead, Judge.
You're saying strict scrutiny is what applies here.
That's right. That's exactly the deal.
Judge Bennett was wrong in the way he handled it.
That's exactly right. Yeah, I want to be clear. Our primary argument is that the proper test here is Daily Mail's, functionally a strict scrutiny test, right? And in fact, we think not just is it a strict scrutiny test under Daily Mail, we think that the Supreme Court in Cox Broadcasting, in applying that test to publicly released court documents, has already done the weighing under that test. We think when it comes to releasing publicly available court documents, the Supreme Court's decision in Cox Broadcasting makes clear that there is no state interest of the highest order. It's not narrowly tailored when you release those to the public to try and restrict the dissemination on the back end. So that's exactly right. Our view is that that is the correct test that applies here. I was simply making the point that even if under that lower test that the state is urging, the statute would still fail.
Well, how did Judge Bennett?
Sorry,
you say it's an easy case. Judge Bennett's a pretty wise fellow. How do you make such a error then, in your view?
Right. I think he mistakenly treated this as a time, place, manner restriction when it's not. It's not, that is Section 1201, when it's not a time, place, manner restriction. It's not limited in the way that, say, Rule 53 of the Federal Rules of Criminal Procedure is to a specific time or place, right? That's why the people that have been threatened with under this statute, the Maryland statute, have been threatened for engaging in conduct outside of the courtroom well after these proceedings have ended. I'm sorry, I can see that my time is up. I'm happy to answer any other.
No, Judge Harris has some questions, I think. I interrupted her.
No, it's fine. I did have just one question. Your argument, and I understand it, it seems to come, I understand the degree to which it is rooted in Supreme Court case law, so I don't mean to put you on the spot, but it does seem to put Maryland in kind of an unusual position, right? Where if they wanted to, they could just not give out these tapes. And then that would be fine, right? There wouldn't be a Daily Mail argument anymore. And so it kind of puts the state to an all or nothing choice. There's no middle ground where we would like to make this available on sort of a limited basis, but maybe not see it on TV or over the internet where it will last forever and it can be monkeyed around with and manipulated. There's no middle ground available to the state. And it just seems sort of counterintuitive. I want to give you a chance to address this, that we would end up with a rule, kind of a free speech rule that might lead a lot of states to make information even less accessible to the public.
Sure, I appreciate that, Judge Harrison. A couple of responses. I guess the first is just on that, is there a middle ground? I think one of your earlier questions alluded to a potential middle ground, which would be letting people come to the courthouse and listen and not actually handing out the recordings. But I understand that would be less, access friendly, I think, as you put it. The reality is, just if we're talking about other states, Maryland is the only state that puts this prohibition on dissemination after releasing recordings. As we note in our brief, there are actually dozens of other jurisdictions across the country that release these recordings without any subsequent restriction on dissemination. I'm not aware of any other state, and Maryland certainly hasn't identified one, that does it in this way, which is releasing the recordings and then restricting dissemination on the back end. But to get to the heart of your question, is this a weird doctrinal rule? I think the answer is it's not. And the reason is, if there really are important interests for the state to protect, right? That is, if there's an actual harm that comes from releasing information about public court proceedings to the public, and I'm skeptical about those harms. I think the state has overstated them. But if there is a harm there, then we do want to incentivize the state to take measures to prevent that harm from arising. And releasing recordings to anybody who walks in off the streets is not a good way of doing it. The idea here is, to quote Judge Davis from his concurrence in the Ostergren case, or to paraphrase, the state needs to both walk the walk and talk the talk. And so it does make sense to put states to have them put their money where their mouth is. If they think there's a real harm there, and again, I don't think there's evidence that there is a real harm, but if there is a real harm of the public knowing what's happening in open court proceedings, the state needs to take the measures to protect against that harm fully. I can see that my time is up. I'm happy to return in rebuttal.
Judge Rushing, Judge Harris, any further questions? Thank you, sir.
No, thank you.
Thank you.
Mr. Bullock, Professor Bullock, you there?
Your Honors, Eugene Wallach, representing Amicus Cato Institute. Your Honors, if I might turn to... I'm sorry?
I said, good to have you with us.
Always a great pleasure to argue in the Fourth Circuit. Your Honors, if I might turn to Judge Harris's question, I think it's an excellent question to ask in general about many features of First Amendment law. That sometimes the rule is once the government does something, it has to do it in a way that's consistent with the First Amendment. So, for example, Florida Star v. BJF says once you release certain information, you can't then claw it back. That is to say, the government can't claw it back. The government can't punish the publication of it. It's true, it creates an incentive for the government to just try to hold that information very tightly. But that's, I think, one feature of the freedom of speech, which is that once people have information, it is an additional burden on them, a very serious and generally unconstitutional burden, to say they can't speak about it, or they can only speak about it in certain ways. So indeed, sometimes that means that the government, put to the choice, would say, we're going to just not provide this information at all. But that's, I think, a feature of the free speech clause. Another situation where this often arises is with the rule that you can't have content-based restrictions. So Kerry v. Brown strikes down content-based limits on residential picketing, which allowed labor picketing, but not other picketing. That actually created an incentive for the government to have a content-neutral, broader ban on residential picketing, which in fact was later upheld in Frisbee v. Schultz. But again, I think that's a feature of First Amendment law, that sometimes a rule, in that case, the rule against content discrimination, if enforced, might sometimes lead the government to implement broader restrictions, but those would at least be constitutionally permissible restrictions. Likewise, if this rule, if the rule that the appellants and Miki are arguing for is adopted, it's conceivable that Maryland might say we won't release it at all. We hope that won't be so, but in any event, the First Amendment does require that, because once information is released, it abridges the freedom of speech to tell people they can't say it, they can't recommunicate. Another important feature, which echoes, I think, something that, or builds on something that appellant counsel had said, is the requirement that the alternative channels, even for a content-neutral restriction, be ample. And the lead case on that is City of Ladue versus Galeo. And we think that that illustrates why the alternatives that the state suggests are sufficient are actually not sufficient. Yes, Your Honor. Judge Harris, I'm sorry, do you have a question?
No.
I'm sorry, your light went on. In City of Ladue versus Galeo, the government said, well, you can't put up signs in your windows, but there are other things you could do. You maybe could leaflet on the street, or maybe you could go and put something up at some community bulletin boards. And the court said those are not adequate alternatives. They're certainly not the ample alternatives required by the time, place, and manner restriction test, because first, they're more expensive, and hiring actors to do a reenactment is always going to be more expensive, assuming you're going to pay for professionals to do the job, to do a good job. And second, they lack the same message. When we hear something is a reenactment, we rightly are skeptical. Is it an accurate reenactment? Could the intonation be different? Could the emphasis be different? Could the meaning even be different if the punctuation is sort of misattributed? Whereas if we hear the actual audio of something, that conveys a different message. It conveys a message with far greater verisimilitude. This is one reason why various circuits have held that there is a right to video record in public places, to be sure, not in a courthouse, but on a public street. A video record, for example, police officers doing their job. Why? Because that has a verisimilitude to it that mere witness accounts do not have. It has an accuracy to it. The same thing goes here. So even viewing this as a content-neutral restriction on speech, the intermediate scrutiny test ought not apply, because it fails to leave open ample alternative channels for communicating the actual words that were said in the actual voice in which they were said. We also think that even
this is Judge Harris.
Yes, Your Honor.
Professor, So I'm remembering right, am I not? That it's your brief that urges that we apply the constitutional avoidance doctrine and adopt an alternative reading of section 1201. Is that right?
Yes, Your Honor.
Yeah. Do you want to talk? Do you want to talk about that at all? Does it matter to us that the parties aren't urging us to adopt that reading? Does that prevent us from adopting it?
Your Honor, I don't think so. I think the question before you is what is the sensible interpretation of the statute that you're being called on to evaluate. And if you think that this interpretation that we suggest is the right one, I don't think anything prevents you from choosing what you think is the right interpretation. The reason
Professor Volokh, this is Judge Pressing. Doesn't Maryland court's interpretation prevent us from interpreting this statute differently or this rule differently? I know it's not in a sort of official court ruling, but judges of the Maryland courts are the ones who have threatened to hold parties or hold individuals in contempt for violating this rule in a way that's contrary to what you say is the best reading of the rule.
Your Honor, as I understand it, while this court is certainly bound by an authoritative construction of the rule by Maryland's highest appellate court, and while it would also, in the absence of such a construction, want to figure out what the Maryland appellate courts are likely, how they're likely to interpret it, we don't believe that it is bound by the interpretation put on it by trial courts.
Right, but what have you given us to interpret how the courts are likely to interpret this? I did some digging on this rule and any other similar rules or statutes, and I really couldn't come up with much guidance from the Maryland courts on how they would interpret this rule aside from these these threats of contempt.
Yes, Your Honor, that's right. We are unaware of any such guidance either, which is why we think there is an ambiguity in the rule that ought to be interpreted in light of the constitutional avoidance canon. And we think that Maryland courts would presumably consider the constitutional avoidance canon just as this court would. So we do think there are at the very least, very serious First Amendment problems with telling people, here, we're giving you this information. It is illegal for you to reconvey it in the medium that's sort of the normal medium for you to do that, the medium that provides the most accuracy and verisimilitude. And the better interpretation is to say that this rule is about recording or broadcasting the matters while they're from the courtroom. That if you're in court, just like in a federal court, you can't just go and record the hearing or broadcast the hearing from the courtroom. That is the focus of this rule, in which case it's very familiar, not at all the outlier that it would be under the state's interpretation.
Thank you very much, sir.
Your Honors, thank you very much.
Appreciate it. Good to have you with us. Mr. Sullivan? Are you there?
Sorry, Your Honor, I was muted.
All right.
May it please the court. I'd like to address a couple of the matters that came up in the questioning just now. Two in particular. One is whether there's anything in these recordings of substance that the plaintiffs can't convey freely to the public. And second, whether the fact that information has been made public always eliminates any interest that the government might have in trying to protect further publication of that information. First of all, plaintiffs do not even argue that there's any content, anything of substance that they can't communicate because of this rule. Instead, they say what's missing, if the recordings are not available to the public, what's missing is a judge's tone, a witness's hesitation, or a lawyer's inflection. That's in their brief at page 37. Well, for one thing, there's binding precedent on that particular point. Whatever else one makes of Nixon versus Warner Communications, it can't be denied that the same argument was made, that unless the public has access to the actual recordings, they won't be able to make their own judgments as to their meaning based on inflection and emphasis. The Supreme Court rejected that.
Counsel, this is Judge Harris. Counsel, this is Judge Harris, and I feel like you are really mixing apples and oranges here. for purposes of the Daily Mail line of cases where the government has already made the subject information available to the public, I mean, what matters is what exactly did the government make available to the public, because that is the thing under Daily Mail where under the First Amendment, the state is presumptively not allowed to prohibit further dissemination. And here, it's the state that made the judgment. We're not just giving you the cold transcript. We are giving you an actual audio recording, or in some cases, a video recording. And so once you're under that set of circumstances and the Daily Mail line of cases, I'm not sure it really matters very much whether it might be sufficient as a freestanding matter to, access to the courts could be satisfied by a cold paper transcript. Because here, that's not what the state has made publicly available.
I understand that, Your Honor, and that gets to the second item that I would like to address, and that is, in this court's decision in Ostergren, on which the plaintiffs rely, this court actually distinguished the Cox and Daily Mail line of cases in their discussion of whether the state had an interest and whether it was narrowly tailored in that Social Security number case, distinguished those cases, the cat out of the bag cases, as counsel referred to it, as referring to instances where secrecy is the interest that is trying to be protected by the law. And the court there analyzed it so that the same logic does not, it has less force or may not apply at all, where the interest is not secrecy, but control over further publication and use of that information, as was the case in Ostergren. So in this case, secrecy is not the interest at all. These are public proceedings. They have to be public proceedings, and Maryland does everything it can to facilitate the access to the public. What is at stake is the harms.
I thought you apply this thing to grand jury material.
Well, grand jury material, the interest is secrecy because those are not public proceedings.
I thought grand jury was in your rule. It is. It's in your statute.
Right. Well, that part of it, yes. If plaintiffs do not claim to have any interest in accessing recordings of grand jury, so it's not at stake here. But what they are claiming is a right to further publicize court recordings. And the same analysis that the court did in Ostergren would apply here, because the interest is in preserving the ability to have.
These things are public records, aren't they? These things are public records. They go down to the courthouse and get it from a clerk.
They certainly are. But one of the things
all they have to do is pay the copying costs, then walk out of there with it.
Yes, Your Honor, that's perfectly true, Judge King. But that's another point that was addressed in Ostergren. The court drew the distinction between the fact that something is public and can be accessed by going to a courthouse somewhere, and whether it is available all at once in one-stop shopping. When you turn on your computer, you get all of the information about a particular person you can. Those are different considerations, as this court pointed out in Ostergren. So here, what the harms that have been identified by the state, particularly by the 2008 committee to consider extended media coverage, was that people react differently in trials. The trial participants are affected by whether the proceedings are going to be broadcast, whether it's the audio or the visual or both. And that panel concluded, based on its review of extensive empirical information and studies and the testimony from people on both sides, from the media and from all the trial participants, they unanimously concluded that there is no doubt in the literature that the ability to publicize the actual performance in court affects the way jurors and witnesses view the process. It may cause witnesses to develop amnesia, as one of the prosecutors who testified before that committee said.
But counsel, I'm sorry, if the state has that concern, why is the state handing out audio recordings and on occasion video recordings? It just doesn't, I don't understand.
Well, Your Honor, it's really testimony to how the state's commitment to having public trials and making as much available to the public as it can, while still trying as best it can to protect the interest in future trials, to make sure they can be conducted fairly and with
if
integrity.
you're worried about witnesses being intimidated, it seems like what you would. I mean, it just seems incomprehensible to me that at the same time you'd be handing out recordings that, you know, people involved with the trial could run down to the courthouse and get and play it for potential witnesses. Listen to this. Like, it is hard for me to sorry, word. It is hard for me to not credit exactly, but believe that the state considers this to be such a big problem if it isn't taking very, very basic steps to address it.
Your Honor, I see the point of that, but that is a problem inherent in the requirement of public trials. The most dangerous person in your community.
No one is requiring Maryland to. Is there an argument in this case, or sort of out in the world, that Maryland is required not just to let people come to the court and witness the proceedings, not just to let them listen on site to an audio recording or watch a video recording if for some reason they can't be there, but to leave the courthouse with a videotape in their pocket?
There is no such requirement, and Judge Harris was right earlier to say that if the state wanted to, it could simply eliminate all of the issues raised by plaintiffs here by not allowing access to the recordings. And it's been conceded that that would be within the state's constitutional power. What the state has tried to do is try to be more accommodating to the public than it absolutely has to under the Constitution, as it tries to balance these concerns, competing concerns, First Amendment versus Sixth Amendment. And the Supreme Court has refused to develop a hierarchy that would say that one of those amendments has to give way to the other. So the state's put in a very difficult position, as Judge Harris also mentioned, of how do you balance this?
When you say the Sixth Amendment, you're saying that this is going to create an unfair trial in a criminal case?
Yes, the 2008 committee that looked into it had ample empirical data from various sources, including surveys of many.
Well, judges routinely instruct the jury not to read the newspapers and not to watch the television and all that. They do it every day.
But the trial judge never.
They do it when the jurors go on breaks. I mean,
the trial judge is helpless.
For years.
Yes, Your Honor, but the trial judge is helpless to do anything about the witness who tells the attorney interviewing that witness before trial, I simply don't remember the event. That witness never appears before the judge. There's no way to impeach that. There's no way to correct for that. And on appeal, I can't really foresee a decision of this court saying, we imagine that there were other witnesses who could have come forward, but they were scared off or developed amnesia. That's not going to be a basis for reversal.
But judges tell the jury they have to try the case based on the evidence, based on the law and the evidence in the courtroom, but not to consider it outside the courtroom.
And that's the serious danger. That's
the way cases are tried.
But based
every
on
day.
Yes, I totally agree.
Jurors are presumed to follow the instructions of the judge.
But witnesses can't be assumed to do so when they don't even show up because they're either intimidated or they simply say, I can get out of going to court by simply saying, I don't remember. And who's going to call that witness? I certainly wouldn't. But Your Honor, the danger is that the data, extensive data, explored by the committee in 2008 showed that witnesses and jurors, but the main danger that I think the state should be worried about is witnesses. Because if courts cannot perform their truth-seeking function reliably and accurately, then what is the point of this whole business? And the worry is that people do have a concern about their image and voice appearing not just on the nightly news, one little 5-minute blip, but if it gets on the internet, it's there globally and forever, or at least until the fall of civilization does the internet in. So those are serious concerns that the case law that plaintiffs cite doesn't take into consideration because it really hadn't developed yet in some of these older cases, that the internet changes qualitatively and quantitatively the potential for these recordings to influence and discourage truthful testimony.
Counsel, this is Judge Harris. I'm trying to get a handle on the structure of your argument. It seems, well, assuming sort of hypothetically that under Daily Mail, look, the rule is the rule. If the government makes this available to the public, it needs a very, very compellingly good reason to then tell members of the public the thing we just gave you, you can't share. Is your argument that the internet changes things enough that now maybe you could meet that very high, something like strict scrutiny? Or is your argument, no, Daily Mail doesn't apply at all because now the interest is so much higher on the part of the state? I mean, it seems like it would be an argument for why you could meet Daily Mail scrutiny, but maybe you're saying something different.
I think the combination of the undeniably important interest, if our courts do not have the highest interest in assuring fairness and accuracy of their truth-seeking function, then really there is no other interest that I can imagine that would be elevated above that. So I think we could meet it, although I've practiced long enough to know not to bet on that successful outcome were that challenge to be brought. But I think it really does change qualitatively and quantitatively, because now it's not just that your face and voice appeared on the nightly news in your locality and you may have a period of embarrassment or humiliation. It can be on the internet everywhere. And the experiences with social media and the kind of trolling and bullying and humiliation that goes on every single day, 24/7 on the internet, while maybe the First Amendment doesn't prevent that, it creates a serious problem about making people want to think twice before participating in a trial that might make them the next subject of a successful podcast exploring all the minutiae of that particular trial. So there is an interest in trying to protect against it.
Are you saying the Daily Mail case is outdated or it's been superseded by the internet, or what do you want us to? You want us to overrule it, or
no?
What do you want?
You don't need to. In Ostergren, you didn't overrule Cox. Of course, you can't overrule Cox. You didn't overrule Daily Mail. But what you did was say, look closely at what was being protected there. And that's distinguishable, the secrecy that was being protected there.
Well, they admitted in the Daily Mail case that they had an interest in trying to protect a juvenile. It was the name of a youngster.
And it was secrecy that they were trying to protect. The identity was not known publicly.
That's right, but it was already in the public domain the day before.
Well, courts take
it was on the radio.
Well, courts take exceedingly extensive measures to try to protect juveniles from the harm that they may incur. And there's many laws in Maryland that apply to juvenile proceedings that wouldn't fly in any other kind of proceeding. Protecting that identity is one of those considerations. But here we don't have any such. We can't narrow what the interest is down to this particular factoid is being kept confidential, and therefore, as long as that factoid gets out in the public, the interest evaporates. The interest is protecting against the situation where neither party in a criminal proceeding, the prosecution nor the defense, is able to put on the case that their client deserves because witnesses are affected one way or the other. Sometimes they're affected by being discouraged, and as the data also shows, some are encouraged to embellish their accounts because they'd love to be on the internet. They'd love to be on television. But I think that sort of thing could be impeached. An embellished witness, jurors can often see through that. But what can't be impeached is someone that simply doesn't show up because she told the prosecutor, I don't remember a darn thing about that incident. And that's the kind of thing that was identified in the 2008 committee that looked into all of this as likely to happen when the court proceedings themselves are available 24/7 and globally on the internet.
Well, counsel, can I just ask you go ahead, Judge King.
I'm just going to say the internet did not render the Daily Mail decision outdated or archaic. I mean, it was a unanimous decision of the Supreme Court of the United States, which upheld a unanimous decision for the record of my state Supreme Court in West Virginia. Ruled the same way the Supreme Court of the United States did. Every judge that heard the case ruled the same way.
I agree with that, Your Honor, and I am not arguing at all for overruling any of those decisions.
Well, you want us to narrow it, supersede it, or something.
But you've already done that in Ostergren, at least your court has. I don't recall whether you were on that panel in Ostergren. But there, the court took a very wise, I think, approach. Say, let's look at what was being protected in those cases, which was secrecy of particular facts. And that is not it issue. It's a much more difficult challenge that the state of Maryland has before it in trying to control this problem that's been identified and confirmed with empirical data that further publication of court proceedings and proliferation of that affects the trial participants in ways that can damage the fairness and the ability of those proceedings to produce a correct and true outcome. And as Judge Harris indicated, we shouldn't be put in a position where we have no choice. You know, we've either got to totally cut off the public, make all of these plaintiffs' jobs more difficult because they can't get a copy of the tape and listen to it and maybe see if there's something else going on that they missed before. We either have to take that tack, which would be constitutional according to plaintiffs, or we subject ourselves to further harm to the process and the fairness of our proceedings because we've got to just let the recipient of the tape do whatever that person wants with it. And I understand that that really is difficult to justify, but I think in this case, on these facts, I think it is justified.
Counsel, this is Judge Harris, can I ask you sort of a different question, which is why after the Supreme Court's decision in Reed, this isn't also subject to strict scrutiny because it's content-based? Because to know whether or not you could include an audio tape on a podcast, you would have to examine its content, see whether it's from a criminal proceeding or not.
Yes, Your Honor.
It seems just like we've gone to a very formal sense of what counts as content-based, and if you have to examine the content to know whether you can put it on your podcast, it's content-based. So why isn't that a problem for you here?
Your Honor, I think it's not a problem for the same reason that Chief Justice Roberts said there wasn't a problem in the McCullen case, the 35-foot buffer zone in the abortion clinic case. There, the Supreme Court rejected the argument that the law was content-based, even though it applied only for abortion clinics, because—
But you didn't have to look at what the sign said. He said it wasn't content-based because it doesn't matter what the sign says. All you have to know is someone is outside an abortion clinic. Here, you're going to have to know, you're sitting there, you're making your podcast. At that moment, when you decide whether or not you can use this audio tape, you have to listen to it and see what it says. That just seems like a really different situation.
Two things, one legal and one factual. And one is, it's not what Chief Justice Roberts said in McCullen. He said, in this case, it's not a question of what people say, it's where they say it. There it was, if you say it within the 35-foot perimeter. Here, it's if it's said in court and captured on these recordings.
No. You're switching actors. Who is the person doing the saying is the person making the podcast. So it is very much about what that person wants to say in his or her podcast, and in order to figure out whether the rule applies to that person, not the person doing the speaking at the criminal trial, but the person making the podcast, that person has to examine the content to know whether or not the rule applies.
I don't think that, based on McCullen, I don't think you can derive content-based from just the subject matter of what it is. It's criminal. It includes all manner of speech which can happen within a criminal proceeding, whether that is pro-government, anti-government, pro-one.
There was a rule sort of like that, I think, before Reed and McCullen, but it's really narrowed down to, if you have to examine the content to know whether the restriction applies, it's content-based. So I mean, I'm not sure it matters because this is sort of an alternative reason why you might apply strict scrutiny in this case, but I am troubled by whether, in light of recent Supreme Court precedent, we could say this is subject matter, but not content-based.
Well, I think that you can, because it would open up, if everything becomes content-based because it's, you know, which category of the library to look it up under, then all manner of laws, your criminal rules, which limit—
Right, and that's what the dissenters keep saying in cases like Reed in the Supreme Court. Exactly so. This is a very, very broad conception of what counts as content-based, and we are concerned that we will end up striking down all kinds of economic regulation and other rules that have nothing, that are not at all aimed at regulating speech. But nevertheless, that seems to be the rule that the Supreme Court has adopted.
Yes, Your Honor. Could I say one more thing? I see I'm in red now, if the court would indulge me.
You can say one more thing, certainly.
Our courts often go to lengths to protect the fairness and accuracy of the trial that would not be tolerated in any other segment of our society, such as for jurors. In United States versus Lawson, this court's case at 677 F 3rd 629. Yes? Hello?
Go ahead.
There, the court quoted with approval the instructions to the jurors that during their deliberations, they could not discuss with anyone through any medium anything about the case. A complete prohibition on any content being expressed. And in that very case, a juror was held in contempt by doing something that is acceptable in every other context in America, and that is consulting a dictionary. Something that ordinarily government would encourage people to improve their diction by consulting dictionaries. But in that case, because it was necessary to insulate the trial from outside influences that corrupt the fairness and the truth-seeking function, the court takes those measures. Unless there's further questions, thank you, Your Honor.
Thank you, Mr. Sullivan. We appreciate it very much.
Sure.
Mr. Riley?
Yes, thank you, Your Honor. I'd like to just briefly address this constitutional avoidance point, just because it didn't come up in our brief, and just briefly explain why plaintiffs are not urging that approach in this case. It's largely for the reason that I think Judge Rushing was alluding to and identified in her question, which is that at the end of the day, if our plaintiffs are charged in a Maryland state court with contempt for disseminating court recordings, at the end of the day, those Maryland state courts that are adjudicating those criminal proceedings or whatever other proceedings they might be are not going to be bound by a federal court ruling construing a Maryland statute. And as Judge Rushing noted, we have at this point a good sense of, I think, how Maryland courts would construe it. Whereas, a First Amendment ruling on a question of federal law, I think, would carry more weight and would be more protective of the plaintiffs here. The second point I'd like to address is just going to this question that Judge Harris had raised and came back to about.
Are you arguing for an exception to the constitutional avoidance doctrine?
Not an except. I'm sorry, go ahead.
Maybe you and I don't understand it the same way. The constitutional avoidance doctrine.
Right. My understanding of the constitutional avoidance doctrine is that it's typically invoked in federal cases. I think there was actually, and there may still be, a circuit split on whether the extent to which a federal court can construe a state statute contrary to the construction of state officials in a constitutional avoidance posture. I don't think that the court needs to reach that here. I was just articulating why plaintiffs would be concerned if all that they got was a judicial determination from a federal court construing a Maryland statute. I think it would be of limited protective value to them moving forward. On the question that Judge Harris...
We don't give advisory opinions. You understand that?
Absolutely, and I don't think we're seeking an advisory opinion. We believe that this is currently infringing plaintiffs' First Amendment rights. They're not able to engage in protected speech activity as a result of this statute. That's the claim that we're asserting here. I don't think it would be advisory to issue that opinion, which is the declaratory judgment that plaintiffs are seeking here. To Judge Harris's question about Maryland potentially going back and restricting access here, I would note there's an additional constraint here, which is the political constraint, which is that Maryland has been handing out these recordings for the past 20 years. Many of these recordings are already out there. And then on top of that, rescinding this rule, which is, again, current Maryland state law, there is a political cost to that I would hope would impose some constraint on what Maryland does. I'd also just like to correct a point that Mr. Sullivan raised, which is that plaintiffs have not conceded that it would be perfectly constitutional for Maryland to restrict access to all court recordings in the future. There may well be constitutional problems with that. They're not implicated in this case because plaintiffs have court recordings in their possession. And the question in this case is, what can they do with them? But insofar as Maryland is using audio recordings of court proceedings as their official transcripts, which they appear to be doing, there is a wide body of case law recognizing, as the Abrams Institute's amicus brief lays out, the First Amendment right to transcripts of proceedings. So again, there are other questions I think that would come into play in terms of what the scope of that right of access is, but we are certainly not acknowledging or conceding the state of Maryland could restrict access, and it would be perfectly constitutional. We just don't think those questions are implicated here. Finally, I would just note that all of the cases when the state invokes these extreme restrictions on people's speech, those are all individual cases based on specific circumstances in those cases. What the state has not cited is any case involving a blanket rule like this. And in fact, there's plenty of case law rejecting a blanket rule, including the language in Chandler v. Florida. I can see that my time is up. I'm happy to answer any other questions the court might have.
Judge Rushing, Judge Harris, further questions? Mr. Riley, we appreciate it.
Thank you very much. Thank you very much.
As well as the arguments of your fellow lawyers. We'll take this case under advisement. And if we were in Richmond with you, we would come to the well of the court and greet you and shake hands with you and tell you what a fine job you did. So we'll just tell you, I'll tell you that on behalf of Judge Harris and Judge Rushing, that all of you did a great job, and we're glad to have you with us. But under the circumstances, we'll have to wait till next time to reach you in Richmond. So we'll call the next case, Madam Clerk.
194703, United States. Ms. Remy?
Yes.
Mr.
Is the court ready?
Yes, Ms. Remy?
Yes, sir.
Remy? Did I mispronounce your name?
No,
Ms. Remy?
It's Remy. Thank you.
Good to have you with us.
Pleasure to be
Thank
here.
you.
Good afternoon, and may it please the court. Mr. Green asks this court to do the same that the 3rd, 6th, 10th, and 11th circuits have already done, and find that Hobbs Act robbery does not qualify as a crime of violence under the career offender guidelines. As we all know, there are 2 ways that an offense can qualify as a crime of violence under the career offender guideline. It can qualify under the force clause if it has as an element the use, attempted use, or threatened use of physical force against the person of another, or it can qualify under the enumerated offenses clause as any one of the specified enumerated crimes contained within that portion of the guideline. And in this case, at dispute is whether or not it would qualify as robbery or extortion under the enumerated offenses clause. To answer that question, we apply the categorical approach, which requires a comparison of the scope of the conduct covered by the statutory elements of the crime with 4B1.2a's definition of a crime of violence. And if the statute sweeps more broadly than 4B1.2a's definition, then any conviction under that statute cannot count as a crime of violence. As I started out, there are 4 circuits already that have ruled exactly as we are asking the court to do so in this case. So all those.
How many of them have ruled against you, Ms. Ramey?
Not aware of any that have ruled against us yet, Your Honor. We've got the 3rd Circuit, the 6th Circuit, the 10th Circuit, and the 11th Circuit all squarely address the issue that we're talking about here today. And I think we can lump in the 9th Circuit as well, the Unitas versus Edling, because what was under evaluation there was a Nevada robbery statute that, but for the addition of some gender-specific pronouns, is identical to the Hobbs Act robbery statute. So really, it's 5 circuits that have already ruled and formed what I've called a wall of authority that really supports Mr. Green's position in this case.
So everybody's with you. How did this case end up on the other side of that group?
Well, unfortunately, the district court erred in finding that Mr. Green was a career offender in this case, and we believe that was error in this case. All of the circuits that have encountered this issue have determined that Hobbs Act robbery does not qualify under the force clause. It doesn't qualify as generic robbery under the enumerated offenses clause, and it doesn't qualify as guidelines extortion under the enumerated offenses clause either.
But you're just looking at the guidelines definition, right?
Yes.
Statutory definition is a different thing.
I'm sorry, maybe I misunderstood the court's question.
The statutory definition is there's a different thing.
Yes, so looking at the definition of Hobbs Act robbery, what's clear is that it permits the crime to be committed by the use or threatened use of force against the person or property. And when you compare that using the categorical approach with the force clause definition, which is that the offense has as an element the use, attempted use, or threatened use of physical force against the person, it's clear that there is more conduct that is criminalized by Hobbs Act robbery than is captured within the force clause definition. And so for that reason, all of the other courts to examine and consider this issue have determined that there is a mismatch and that Hobbs Act robbery categorically fails to qualify under the force clause. Likewise, doing a similar comparison, looking at the generic robbery definition, it's really the same, very similar analysis. So you're comparing the Hobbs Act robbery definition with what this court has defined as, generic robbery as the misappropriation of property under circumstances involving immediate danger to the person. So we've got two problems there. One is the immediacy requirement. And when you compare that against the Hobbs Act robbery statute, that says that Hobbs Act robbery can be committed with actual or threatened force immediate or in the future. So there's an immediacy requirement that's in the generic robbery definition that we think takes it out here. And then, of course, it requires that threat of danger be to the person, whereas Hobbs Act robbery is more broad than that and includes a threat to a person or property. And again, all of the circuits to examine this issue have determined that under the enumerated offenses clause, generic robbery, Hobbs Act robbery does not fit the definition of generic robbery. And then finally—
Counsel, this is Judge Harris. Look, Counsel, Judge Harris, just quickly, am I remembering right that it's the government, that's also been the government's position in several of these cases?
Yes. The government is essentially, well, going to the force clause, I mean, the government, that's something that the courts that have examined the issue really dispensed with relatively quickly in their decisions. It was described basically as an obvious answer to the question in one of them. And then, yes, in one of the cases, the government actually conceded the issue under the force clause.
Okay.
Which case was that?
Trying to recall it. I believe they conceded the issue in Cam.
I believe it was in Rodriguez in the Third Circuit, right? And the government didn't just concede it under the force clause. I think they conceded it under guidelines robbery as well. And there was only a discussion of extortion, if I'm recalling that correctly.
I think the court's right. The primary focus and the biggest point of contention on the merits has been under the extortion definition. And even though I would say less than half, it was basically O'Connor that ultimately found that the rule of lenity applied. Most of the courts did not even go to the rule of lenity. Most of the courts determined that the most natural reading of physical injury in that definition means bodily injury. And so the general conclusion across the board is that, again, Hobbs Act robbery is more broad as enumerated extortion. And so with all of these cases, all of these circuits that have ruled exactly the way that we're proposing this court should rule, we believe that on the merits, this is a very strong case for Mr. Green. It's a very straightforward analysis. It's just a simple comparison under the categorical approach of Hobbs Act robbery statute to each of the potential definitions. And under each one, it fails to qualify, and it's clear. So we believe that this government or this court should follow suit and follow what O'Connor in the 10th Circuit, Camp in the 6th Circuit, Rodriguez in the 3rd Circuit, Eason in the 11th Circuit. That was the most recent case to deal with this. And also lumping in Edling out of the 9th Circuit. We believe that they have ruled on this issue correctly, and this court should join those circuits in ruling that Hobbs Act robbery does not qualify as a crime of violence under the career offender guideline.
Very good, Ms. Reedy. Let's see what Mr. Alston has to say.
Certainly.
Mr. Alston, are you out there?
Good afternoon, Your Honor.
Good to have you with us, sir.
Thank you, Judge King. Good afternoon, Your Honors, and may it please the court. The United States asks that the court affirm the sentence imposed by the district court for Mr. Green's third conviction for an armed robbery, while we have spent, or I should say the panel has spent much time with my colleague about the career offender provision. I note that as the government frames the issue, this is one where we look at the sentence in its entirety, not only the application of the provision, but also whether there was procedural and substantive reasonableness under either plain error or the harmless error review standard. I would start by noting that in July 2015, Mr. Green entered a convenience store, brandished a firearm, stole money, and during his escape threatened a bystander and fired a warning shot before leaving the scene.
Mr. Austin, sorry to interrupt you. This is Judge Rushing. The first thing I'm wondering from the government, though, is why are you taking a different position in this case than the government did in the Third Circuit in the Rodriguez case?
Respectfully, Your Honor, I'm not entirely sure of the reasoning for the government's position in the Rodriguez case. I would note that the position taken in this case is consistent with the position taken in Eason, which is actually more recent than Rodriguez. So one might say that the
Counsel,
yes.
Counsel, this is Judge Harris. Just to be clear, in 3 different circuits, the government has conceded that there's not a match with generic robbery. And so I am troubled. Like, the United States only gets to have one position. And are you suggesting that maybe at one time the government's position was that it doesn't match with generic robbery, but then after it lost 4 cases on that point, it changed its position and decided that it did match?
No, Your Honor. I don't believe that I would describe it that way. I don't think it has been a matter of changing its position. I would note that this issue had come up, although it was not decided by this court some time ago, and the position taken in this case remains consistent with that and was not driven by success.
Do you know what Mr. Austin, do you know what the position of the Solicitor General or the criminal division is on this question?
I do not know today, Judge King.
Have you not attempted to ascertain that before you came down here?
I have spoken with the appellate chief within our office about it. I cannot say whether that individual.
But the Maryland office shouldn't be taking a different position. Judge Rushing and Judge Harris got you over a barrel on this one. You should be taking a consistent position with the criminal division and the Solicitor General. You and the other circuits, the other officers in these other cases as well, unless they're out on the limb.
Judge King, I do understand your point. I'm unfortunately not able to say which one of us, to use your phrase, may or may not be out on a limb.
Now somebody is, looks like, or sounds like. Go ahead. I'm sorry to take your time, but
no, certainly. I certainly understand the court's concern about what appear to be some disuniformity among these cases. I think there's, as reflected in the brief, some authority for the positions taken with respect to each of the government's arguments, particularly when looking at the force clause, the citation to Fifth Circuit case in Tellez-Martinez that involved a California statute that is substantially similar to the Hobbs Act robbery, saying that there is a threat of force that can harm the person that is inherent in the taking that is described by that California statute that mirrors the Hobbs Act robbery. So in that sense, there is authority to support that position that it would apply under the force clause. I do understand that other circuits have disagreed, but the government does note that that authority is out there and believes that that authority would support its position. Similarly, there's authority that would support the position that generic robbery would.
No, but we're talking about the position of the United States of America. It should be taking one position in these cases in every court of appeals and in every district court. It should be taking the same position. And I don't think that any attorney general that would ever take exception to that proposition.
Again, I understand that, Judge. I unfortunately am not equipped with the facts that may answer the panel's questions, which I certainly understand, and I don't want to misrepresent anything, and I don't want to be dismissive either. I am not aware of whether the Solicitor General has or has not adopted a formal position on this to be adopted or to be applied across the department and all offices at large. And again, I know that there'd been some shifts even before this case, not that that necessarily addresses the court's concerns, but there seems to be something that perhaps was not settled in those other cases as well. I don't know that helps or aggravates the panel's concerns. Turning back to the categorical approach argument, I would note for the court that the government believes that the cases that find in favor of Mr. Green's position do focus a lot on the distinction of person versus property and the threats there. And I'd like to speak to that briefly, particularly that the government submits here that while it is important to focus on all language of the statute, what's equally important is to focus on the fact that this is a taking of personal property from the victim. And turning back to that Fifth Circuit case in Tellez-Martinez, because of the context, the threat of force is one that would be that would carry this inherent danger to the person, and therefore the force clause may be implicated, and that analysis would apply when considering the generic robbery definition, because that in some aspects again turns on the person versus property dichotomy. I will turn to the extortion argument. As my colleague noted, the courts have spent a bit more time on that. And the issue here from the government's perspective is the party's divergence on physical injury, whether this extends to property. And the government's brief does cite some authority that it believes supports the position that the Hobbs Act reflects the generally accepted definition of extortion, that Lefebvre explains that threats against property are long considered within extortion scope. These understandings would inform how physical injury should be interpreted and construed in this instance. And that really is part of why the government continues to take the position regarding generic extortion. Again, I would note that the Sentencing Commission's comments on the proposed amendment certainly reflect that there was no indication to take Hobbs Act robbery outside of the career offender provision. And the government submits.
Counsel, this is Judge Harris. Can I ask you a question about the Sentencing Commission's commentary?
Yes.
And the Hobbs Act? I feel like I probably am reading this wrong because no other court has been troubled by this, but I am. It sort of looked to me as though what the commission was saying that was, look, we're doing a separate definition now because we're trying to narrow the generic definition. And the generic definition, they say, would be broader under the case law existing at the time of this amendment. Courts are generally defining extortion in a broader way based on the Supreme Court's holding in Nardello, which defines extortion for purposes of the Hobbs Act. And then they say, we want something narrower than that. So it sort of looked to me like whatever else would be in or outside this guidelines definition, the whole point was to make it narrower than Nardello's description or definition of extortion under the Hobbs Act. What am I missing?
Judge, I don't know that I'm not sure what you may be missing. You are right that this is a point that I didn't see raised in some of the other courts. I think the commission was proposing multiple routes here and seeking some comment on which perhaps may be the best route forward. I know one proposal involved preventing the use of the categorical approach entirely, and then another proposal involved redefining some of these offenses to correct what it perceives as some miscommunication about the career offenders provisions extension to the Hobbs Act. I think at bottom what can be taken away is that the commission is intending to, one way or another, ensure that Hobbs Act robbery, which I would note parenthetically is essentially the quintessential federal robbery offense, the archetypal crime of violence. The commission is attempting to find what it perceives as the best way to include or to ensure that Hobbs Act robbery is not excluded, I should say, from the career offender provision. And so whether it comes through a way of redefining extortion or explaining the definition of extortion or redefining robbery or disclaiming any reliance on the categorical approach, I think the commission's intent is clear, and the means by which way it should do it, I think, are in some sense open questions for which it was seeking comment about what may be the most prudent way to do that. I don't know that answers your question about what they were attempting to do, but it's my read that what they're saying there isn't necessarily how they want to resolve this permanently, but rather exploring ways to ensure the Hobbs Act robbery remains within the provision's scope.
All right, thank you.
Just catching my train of thought here. One thing I wanted to emphasize that also was in the briefs, in applying the categorical approach, which the parties do agree applies here. There's been no dispute here. I don't think there's been any dispute in any of the other courts to address this issue. The focus under Taylor is an examination of substantial correspondence, and the government thinks that is important language because the word-for-word match sometimes can lend itself to results that may be counterintuitive in some sense, and it's for those reasons that the government continues to take the position that the guidelines as defined now, understanding that they have endured some change and may endure some in the future, the guidelines as defined now continue to include Hobbs Act robbery, given the long-standing view that Hobbs Act robbery was a crime of violence, and that there is no indication, notwithstanding some of this confusion that Your Honor has pointed out, there's no indication that Hobbs Act robbery is intended to not be considered a crime of violence. In fact, it would lend itself to some uneven and inconsistent applications if the court were to consider conduct to be a crime of violence simply because of some alternative wording in a state statute versus the federal statute. To that point, I would note that Mr. Green has two predicate offenses for state court convictions that were qualifiers for the court's determination, and those involve what are essentially the same conduct. And while I understand that the court looks at elements, not facts, it does speak to how the court should view these statutes that are at issue, and also aim to affect the Sentencing Commission's intent. I'd also like to turn, unless the court has additional questions on the Hobbs Act issue, I do want to speak briefly to the issue of error, because I do believe that is equally important here, notwithstanding the parties' disagreement about the Hobbs Act and the career offender provision. the court need not address the issue ultimately, or I should say that issue is not necessarily dispositive due to the standards of review here. The government maintains that this is a plain error standard because the argument was not raised as framed in the district court, and I certainly understand that Yee versus Escondido counsels that the court may take a broad view as to argument preservation, but I would note two things here. One is that the argument that's now being pressed appeared to be all but disclaimed in the district court in the footnote that is cited in the government's brief, where the trial counsel made the argument that the Hobbs Act robbery conviction was not a predicate qualifying offense, because it was void for vagueness under Beckles. That is the argument that the district court addressed. The rule regarding argument preservation obviously is one that is aimed at fair notice of the substance and issue, to allow not only fair notice to the district court, but also for a full record and rationale to be developed for this court to review.
Counsel,
Yes.
this is Judge Harris. So,
Yes.
I mean, I did find the defendant's argument in his sentencing memorandum somewhat ambiguous, although he also cited Quarles, which is about, an elements-based analysis. So it was hard to get my hands around. But the thing that was really clear was the government's argument in its sentencing memorandum, because it argued expressly Hobbs Act robbery qualifies as a guidelines crime of violence because it matches the enumerated offense of robbery. And so I think the elements question was not just vagueness, was in front of the district court, and I think the district court did allude to it. But what I don't mean to put you on the spot, but what troubled me was that the government's brief was filed in 2019, and the government told the district court just in a sentence, look, Hobbs Act robbery matches generic robbery, at a time when that was contrary to the position the government was taking in other courts, and at a time when at least 3 appellate courts had rejected that argument. And when I think about how this mistake got made, it sort of looks to me like, it's the right way to put this, nobody is exactly above reproach here. That's all I have to say. It seems to me that there was, to the extent that this wasn't properly framed for the district court, I'm not sure the government doesn't share some of the responsibility for that.
I understand your point, Judge Harris, about perhaps some confusion in the fact that this was not ironed out, so to speak, in a sense that there was a uniform front put up for the district court. I do think that does not necessarily preserve the argument that Mr. Green made, but I will say this: the parties' positions on the standard of review are made clear here, given the overlap in some of the Alano elements and the harmless error considerations. The government believes that the result would be the same, because at bottom, in this case, it's going to turn on whether there was an effect on substantial rights. Really, for the purposes of this appeal, I would submit that whether you find that it's plain error or that it's a harmless error review is just a matter of who the burden is upon, whether it's upon Mr. Green to show that Alano was satisfied, or whether it's upon the government to show that the harmless error analysis is satisfied. So turning to that, I would note briefly, Mr. Green's briefs do not, in the government's view, wrestle with the district court's statements as to why it imposed the sentence it imposed. Not even the reply brief wrestles with Savion Matute, McDonald, Gomez Jimenez cases that say that the court need not explicitly say it would have imposed the same sentence absent the disputed enhancement, so long as the record is clear. In here, what I think
Counsel, sorry, it's Judge Harris again, but the court in this case did explicitly say, if I turn out to be wrong about whether or not the career offender enhancement applies, we'll look at this again. I mean, that's kind of the opposite of what you're looking for harmless error review, right? The district court explicitly said.
I would respectfully disagree with that characterization. My understanding, and I was present for the sentencing in this case, is that the district court said, and I am looking now at JA 98, line 4, the district court said we have actual armed robbery The elements, he speaks to the elements, the district court speaks to his finding that it was a predicate offense, and then says, I understand it is an issue that has not been fully decided, so that could affect, we could relook at this again if a higher court were to determine that a Hobbs Act robbery is not a predicate offense. And while that certainly acknowledges that this is an open question, I don't think that's a commitment to saying essentially what Mr. Green thinks the record is saying, which is, I don't think that's a commitment to saying this is going to come back just because I found it as a predicate offense. I think it is the opposite. I think here what we have is a career offender guideline that at the low end was, if I recall correctly, 151 months, a non-career offender guideline that at the high end was 96 months. We have a plea under Federal Rule of Criminal Procedure 11C1C that the sentence would be no less than 120 months. So there was already a contemplation that this sentence would exceed the top of the non-career offender guidelines. And I see that my time is up, if I may at least continue the response to the question.
Go ahead and finish.
What we have here is a sentence that was already going to be above the guidelines. And even then, the court noted that something at the bottom of the agreed upon range, the 120 months, that was the lowest that could be imposed. That would not be sufficient, even for someone with no criminal history. That would not be sufficient given the facts of the offense. Here we have Mr. Green, who had multiple armed robbery convictions in his past. And so that justified something more than even the 120 months. So while I do, Judge Harris, take your point about considering that this could possibly come back, I think that the explanation of the sentence itself, which comes later in the transcript, actually falls within the Salva Matute, Gomez Jimenez, Hargrove, and other harmless error context, because it is clear that the government, that the district court would have imposed a sentence going below the career offender guidelines and well above not only the non-career offender guidelines, but the 120-month agreed upon minimum. And so unless the court has any additional questions for those reasons, the government would ask that the court affirm the sentence imposed in this case.
Thank you, Mr. Austin. Ms. Remy?
Yes. Does the court have any specific question or area that it wants me to focus on? I only have a few minutes, so I'd like to use it to answer the court's questions. Okay. Well, I think then if the court doesn't have any other questions, I would respond just briefly to the idea that it's harmless error. It's not harmless error here. Even though the district court varied downward from the incorrect guidelines range, it greatly impacted the ultimate sentence, which was 144 months that was imposed. And that's 4 years over the top of the non-career offender guidelines range, which was 77 to 96 months. So although the district court said it would not have imposed a 96-month sentence with or without the career offender enhancement, it never said or even hinted it wouldn't have imposed it would have imposed a 144-month sentence without the career offender enhancement. So we believe that the error here makes a huge difference, and that there's a very real possibility that the district court would have sentenced Mr. Green differently if the correct guideline range had been applied. And with that, if the court doesn't have any other specific questions for me, then I have nothing else to present.
Thank you very much. And I take note of the proposition of the fact that you are court appointed. And we really appreciate you working on this case in that status. And we couldn't do our work without lawyers like you.
Thank you very much.
Judge Harris, Judge Rushing, either of you need a break before we go to the next case? Madam Clerk, we'll take this case under advisement.
1923-83, Laura Sue Halpern versus Andrew Saul. Mr. Metaxatos?
Yes, I'm here. Thank you.
Mr. Metaxas, good to have you here, sir.
It's my honor to be appearing before the Fourth Circuit for the first time, Your Honor. And may it please the court.
Tell us how the district court erred here then on behalf of your client. Go right ahead.
Absolutely, Your Honor. In the present case, there are two fundamental errors. First, the Social Security Administration and District Court misread the law by superimposing additional requirements for equaling listing 14.09C1 not found anywhere in the text of the listing. Second, even if the Social Security Administration and District Court read the law correctly, their decision denying my client's claim were not supported by substantial evidence because my client met those heightened requirements. And the law in question is listing 14.09C1, which is intended to deal with another medical impairment, ankylosing spondylitis. But if an individual has an impairment like scoliosis not described in Social Security's listing, equivalents may be made to other listings if they are of equal significance to a listed impairment. And Section 1.00L of Social Security's musculoskeletal listing states that evaluation of equivalence may be made to listing 14.09C if a claimant has scoliosis which results in fixation. The requirements of listing 14.09C1 are simple. Fixation of the dorsolumbar spine shown by 45 degrees or more flexion from the vertical position on medical imaging and physical examination. That is all it requires. And the medical record shows my client met those requirements for almost a 4-year period. But the Social Security Administration and District Court denied my client's claim for benefits because they superimposed additional requirements for equaling listing 14.09C1. Specifically, that the flexion discussed in the listing be forward in nature as opposed to lateral, which is the way spines are fixated with scoliosis, and that the claimant demonstrate an additional extreme limitation. But neither requirement is present in the listing. And again, the irony is that even if the Social Security and District Court read the law correctly, their decision was not supported by substantial evidence because Ms. Halpern had evidence not just of the lateral fixation that's inherent in scoliosis, but also forward fixation, otherwise known as kyphosis. And also, Ms. Halpern had several extreme limitations, including difficulty ambulating and difficulty breathing and eating right before her surgery as her rib cage collapsed into her pelvis and she had difficulty with eating and breathing according to the medical evidence of record.
Counsel?
Yes, Your Honor.
Yeah, this is Judge Rushing. I had a question about that, your second argument there, that yes. if we think at least one part of the ALJ's reasoning was correct, if he was correct in saying that the introductory material does apply to whether you're medically equivalent to the listing, so that your client has to have a serious impairment in her ability to see around herself and ambulate effectively. Are you contesting that finding? Are you saying that the ALJ was wrong to conclude based on the evidence in front of him that she did not have difficulty seeing around herself and ambulating effectively? Because you're relying on these other, the eating and breathing, I understand your brief to not be making the ambulating argument, but I want to make sure I'm understanding you correctly.
Yes, Your Honor. There's evidence that the Ms. Halpern had difficulty ambulating as well. For instance, in August of 2015, she was seen at Carolina Neurosurgery and Spine, and the office notes indicated that she could not stand for long periods of time, and over the past few months had stumbled and fallen a lot. And that's the administrative record, page 728. And I discussed the issue of her actually having an extreme limitation in page 12 of my district court motion for summary judgment brief, as well as in my Court of Appeals reply brief, Your Honor.
So, but just to be clear, the extreme limitation that you claim on appeal, is that the extreme limitation in her ability to ambulate?
Your Honor, I don't think that's the only extreme limitation. I believe that when that is referenced as an example of extreme limitation, it's not preclusive, and that there are others. I think that the most stark one, and the one that I pointed out in my earlier briefing, was her difficulty with breathing and eating right before her surgery.
Okay, I'm really just trying to understand as a factual matter if you are contesting, if you say the ALJ, as a factual matter, you're asking us to find that he was wrong on the facts to determine that your client did not have difficulty ambulating effectively as that's defined by the regulations, or if you're not challenging that factual determination.
I am challenging that, Your Honor. And it doesn't have to be that, that Ms. Halperin had difficulty ambulating throughout the course of the whole 4-year period. As this court has made clear in Radford v. Colvin, so long as there's evidence that all of the elements of the listing were met at least one time or another throughout the course of a 12-month durational period, then that would direct the finding of disability if they meet that or equal that listing. But I should circle back and get to my primary argument, which is that the listing does not require an additional extreme limitation, and it does not require that the fixation or the flexion in nature be forward in nature. I think that Appellee's brief tries to direct this court to the introductory comments of Chapter 14 of the listings, but in the process, they ignored introductory comments to the Chapter 1 listings. And I think that it's interesting when you read Section 1.00L, it talks about impairment of ambulation. And if you have a curvature of your spine, which results in impaired ambulation, and then it directs you to make an equivalence argument to 14.09A, not 14.09C. It goes on to state when an abnormal curvature of the spine results in symptoms related to fixation of the dorsolateral spine, evaluation of equivalence may be made with reference to 14.09C. And that's what I argued before Judge Jacobson, that's what I argued before the district court, and that's what I'm arguing before you today, is that my client met those requirements. She had fixation of her dorsolumbar spine greater than 45 degrees for over a 4-year period from when she first sought the help of an orthopedic specialist in 2013 until she finally had her surgery in 2017. Everything else is superfluous. The requirement that there be kyphosis or forward fixation, I'm still unclear where the argument is that where that comes from in the text of the listing or even the introductory comments for that matter. And again, with respect to the impaired ambulation, that is specifically an argument for equivalence under listing 14.09A, not listing 14.09C. As I've said, however, even if there were such a requirement, I do believe that Ms. Halperin's difficulty with breathing and eating as her rib cage collapsed into her pelvis, I think satisfies the requirement of an extreme limitation.
How old is this lady?
Your Honor, she's just about 40 years old. She was born in August of 1980. And she has had scoliosis since childhood, but as often happens with scoliosis cases, after the birth of her child, things got exacerbated to an extreme degree. Well, if no one has any further questions for now, may it please the court, I'll reserve my time for rebuttal if that's all right.
Very good. Mr. Drum? For the Social Security Administrator, are you there, sir?
I'm sorry, I might have been on mute. Can you hear me now?
We can hear you now. You're there, I believe. So
I apologize.
For a while, you left. Go ahead.
My name is Robert Drum on behalf of the Social Security Administration. It's been many years since I've been in the Fourth Circuit, but I'm glad to be back, even in this new technological format that we have to deal with.
Well, we're glad to have you with us, and all of us are up against this technological problems and because of the COVID. But we're dealing with it, so we'll go through it with you.
Okay. Now,
tell us why your colleague there isn't right. This lady's disabled, it sounds like. She can't hardly walk, can't get around, and she's only 40 years old.
Okay, as to the point made that the listings didn't refer to the introductory listings 1.00, meeting the listings is defined in 404 1525C3 as, we will find that your impairment meets the requirements of the listing when it satisfies all of the criteria in the listing, including any relevant criteria in the introduction, and meets the duration requirement. In order to equal a listing, you have to show symptoms, signs, and medical findings that are at least as significant as the symptoms, signs, and findings required to meet a listing. And in this particular case, the claimant cannot show ineffective ambulation, which is defined in 1.00, capital B, 2, small b. Ineffective ambulation is defined as having insufficient lower extremity function to ambulate effectively, independently, without an assistive device that limits the functioning of both upper extremities. Now, both the ALJ...
Counsel, sorry, this is Judge Harris. I don't understand why we're over there. Just in looking at L, whatever it is, 100.L, which is for scoliosis, it says that if your abnormal curvature of your spine results in symptoms related to spinal fixation, go over to 1409C. And over there, it seems like the medical criteria is the 45 degrees more of flexion from the vertical position. And I'm sorry if I'm mispronouncing either anything or everything. So why hasn't she met that? I don't understand.
Well, we're talking about an equal situation, not a meeting situation, and her curvature is an S curvature, a scoliosis curvature, not a kyphotic forward curvature.
Do you call it an S curvature?
It doesn't.
I'm calling it an S curvature just offhand because it is what a scoliosis curve is, as opposed to kyphosis, which is a forward curvature of the spine. I'm speaking colloquially.
But nothing in this regulation that I just read you distinguishes between those two things. I don't understand. It's not limited to the forward flexion of the spine. It just says flexion. It looked to me like the ALJ, I can't remember if it was the ALJ or the magistrate judge, wrote in there forward flexion, but that's not in the regulation.
No, I think the magistrate judge was simply addressing the argument that was presented to her that the claimant had spinal fixation under 1409C. But
why doesn't the claimant have it?
But it's not simply a matter of the fixation, but there needs to be an extreme limitation. The impairment has to result in an extreme limitation. And one of the examples in the listings is having insufficient ambulation. That's an example. Extreme limitation.
I see that I see the introductory commentary, but I guess what I'm missing, I feel like I'm missing some connective tissue. If you start at L, which covers abnormal curvatures of the spine, including scoliosis, and that takes you to 1409C. And so you're conceding she meets 1049C. You're just saying there's an additional requirement imposed by that introductory commentary. Is that right? So you're not saying she doesn't meet, I'm so sorry, 1409C. She meets that, but the problem is she doesn't meet this introductory commentary.
But I just say there's a distinction between meeting a listing, namely having the specific criteria specified in the listing, and equaling a listing, which is that your impairment results in symptom signs and findings that are at least as severe as the listing would be. So this is an equals case, and that is explained in 404-1526 is the regulations that talk about equaling a listing. And in applying those regulations, the ALJ found that the severity requirements of a listing were not met because the claimant was able to ambulate effectively even up to very shortly before her surgery.
Okay. So I would have thought sorry, counsel, and I promise to stop, but I am genuine. I find this case difficult and I'm appreciating your help. So when I look at the severity thing, where it says listing level severity is shown by an impairment, that part, I would have thought that the severity is the 45 degrees. If your spine is bent at an angle of 45 degrees or more, that's severe. And then it looks to me just kind of plain language, like they're saying, if you have a 45-degree bend in your spine, we will find that that is an extreme limitation. It's like an irrebuttable presumption. But you think it's saying if you have a bend in your spine of 45 degrees, we will find that you have an extreme limitation if you have an ability, if you also can't see in front of you, above of you, and to the side.
Right, but as I say, I understand the conceptual difficulty of this, but in the case of kyphosis, where someone's spine were fixed forward, she wouldn't in fact have that difficulty seeing that the listing talks about. But nonetheless, as both the ALJ and the district court noted, the listing requires more than simply curve measurements. The listing has to result in an extreme limitation, and one example of an extreme limitation is ineffective ambulation. I think, as we pointed out in our brief,
effective ambulation.
Ineffective, and you have to be able to. It has to result in the inability to ambulate effectively.
That means you can't walk.
That means that you have insufficient lower extremity function that limits your ability to walk independently without an assisted device that limits your ability to use both upper extremities. In other words, it contemplates that the individual would be using a walker or two canes. That would be an extreme limitation in the ability to ambulate.
Counsel, sorry, this is Judge Rushing. I thought the introductory material kind of amended that definition a little bit for this particular category, right? It says even if you don't require assisted, something that would require both of your upper extremities. Am I right about that?
You are correct, but as the LJ pointed out correctly, implicit in the listing is an ineffective ambulation requirement. And
can I ask you about that? Just kind of the line of questioning that Judge Harris was pursuing, I think is helpful to understand your position. Do you read this introductory material to mean that to meet the listing, someone also has to show an inability to ambulate effectively, or that if they meet the listing, if they meet what's in there, particularly about the curve, then and they fall under that particular diagnosis, then the agency will find that you have an inability to ambulate effectively. But that if you're not meeting it, if you're trying to make medical equivalency, then by definition you don't meet the listing, and to show that you're at least of the similar severity, then that person would need to show an inability to ambulate effectively. Are you drawing a distinction between those two, between what you need to show for medical equivalence versus what you need to show for meeting, or am I misunderstanding?
Well, I'm drawing a distinction because the listing itself, 1409C1, talks about alkalosis and fixation of the spine forward. Now, she doesn't have those specific findings, so we're in the equals category. We're in 404-1526, equaling a listing. She has to show...
I'm sorry, counsel, can you just say that again? I am trying desperately to follow you, and it just went too fast for me. Say, what is it that she doesn't... Sorry, why are we in the equals and not the meeting?
Okay, to equal the listing, she would have to have the alkalizing spondylosis and the forward fixation of the spine. That's what 1409 talks about. in terms of meeting.
No, it
in other words,
doesn't say forward. It doesn't say forward. This is where I keep getting mixed up. It just says 45 degrees.
Well, it's the definition of it's the particular condition, right? The ankylosis, what have you.
No, but ankylosis just means fixation, right? I'm sorry, Councilor, is it your position that scoliosis is not a form of fixation? Is that where I'm getting mixed up?
Yes, scoliosis is not a form of fixation, yes.
Oh, why do you say that? I thought, does fixation have some specialized meaning beyond just, you know, the bones are fused or stuck together in a way that's, you know, kind of permanent?
Well,
it has some meaning that...
Alkalizing spondylosis is a condition that results in fixation of the spine in a fixed, immovable position.
Right, and why isn't that scoliosis?
Because her spine is not fixed in one position. I mean, for example, during the consultative examination, it was noted that she could climb off and on the examination table. She could move around the examination room without any difficulty. She could squat and arise from a squat, and she didn't have any particular difficulty with moving because her spine is not fixed in one position.
Okay, so you're just, this will be my last question. So you're saying scoliosis could never qualify could never meet the criteria in C. Then that, it seems weird to me then that why then did 100.L send people with scoliosis over to 1409C if by definition they could never meet that criteria?
They can equal the criteria, and that's what this case is. It's an argument that she equals the severity requirements of the listing. But equaling the severity requirements requires an extreme limitation, not simply a curve measurement.
I understand. Okay. So,
and if I may just add one more point here. At the initial and reconsideration levels, two doctors looked at the medical evidence in this case, including her spinal x-ray, and they looked at it under listing 1.00 for curvature of the spine, and they found that the requirements of 1.00 were not met. And 1.04 includes an ineffective ambulation requirement. So what I would say is that doctors looked at this. They looked at the specific medical findings that they had available to them, including the x-ray showing the degree of curvature, but they found, based on the examination findings in the consultative examination, that no listing was met or equal. And yes, the agency's position is that it's not enough to simply have a spinal curvature, but that curvature in an equal situation has to be at least result in limitations that are at least as severe as the findings required to meet a listing. And those findings include a requirement of ineffective ambulation. And we've cited multiple instances in our brief where the claimant had the ability to ambulate effectively, and her gait was normal even very shortly before her surgery, obviously where her condition became more severe. And we are, after all, talking about a very young woman here who was working on a part-time basis to a significant degree during 2016, not enough to amount to substantial gainful activity, but she was in fact working right up until the time on a part-time basis at Staples until shortly before her surgery. And I would suggest that the ability to work even on a part-time basis is suggestive, at least, that she does not have an extreme limitation, an extreme functional limitation from the curvature in her spine, which she has had her entire life. But I'm certainly willing to answer the court's questions.
Mr. Drum?
Yes, Your Honor.
Anything further?
No, Your Honor.
We appreciate it very much. Thank you.
Thank you.
I'm sorry, that wasn't Mr. Mr. Matakos,
I'm here, Your Honor.
you have rebuttal time.
Thank you, Your Honor. I will just note that my client was working part-time through part of the relevant period because her husband was undergoing cancer treatment while she was undergoing her own medical impairments. And she worked on a part-time basis because she physically could not work at a full-time basis, which is the standard for disability. Now, Judge Harris, during the last go-round of questioning, got it precisely right when she indicated that the introductory comments to Chapter 14 create, quote, an irrebuttable presumption that there is an extreme limitation that exists. That's all it does. It does not add, the text of 14.00E1 does not add an additional requirement to listing 14.09C1. It just says, we're automatically going to find that you have an additional extreme limitation when your spine is that profoundly fixated. And that's actually in keeping with Social Security's commentary that they made when they adopted that listing 14.09C1. And if I may offer a quote, we believe ankylosing spondylitis or other spondyloarthropathies with ankylosis of the dorsolateral or cervical spine at 45 degrees or more flexion, documented as required in the final listing of 14.09C1, are in themselves indicative of an impairment that precludes any gainful activity. And that's the Federal Register, volume 73, page number 53, page 14,585. I'm sorry, what's the yes.
Counsel, yeah, it seemed to me like I finally understood this thing about whether scoliosis counts as fixation. It seems like the government's argument turns on this idea that scoliosis doesn't meet the sort of medical criteria that's set out in 14.09C because it's not a fixation at all. So it doesn't matter if it's 45 degrees forward anywhere. It's just not a fixation. It doesn't get in the first word. What's your response to that? Why is that wrong?
If that were the case, Your Honor, my client simply could have strained her spine and wouldn't have needed to undergo a 2-day surgery in which she was intubated following the surgery before she finally was released from the hospital. If you look at footnote 12 of my initial appellant brief, it addresses this point head on, that scoliosis is indeed a form of fixation. It's a reference to the National Institute of Health. It's a study, and it talks about structural scoliosis in which the spine has a fixed curve. And it's just that it's a lateral curve, not a forward curve. But as Judge Harris makes clear, kyphosis or forward fixation appears nowhere in listing 14.09C1. It appears nowhere in the introductory comments to the Chapter 14 listings or in the Chapter 1 introductory comments to the listings. And yes.
This is Judge Rushing. Can I ask you a question along that line?
Of course.
Your client you're not claiming she meets the listing, right? Because she doesn't have ankylosing spondylitis or other, I'm not sure how to pronounce the next word, but it's not exactly within the listing, right? She's trying to medically equal it.
That is correct, Your Honor. In order to meet the listing, I'm sorry to interrupt. Go ahead.
Oh, no. My question is, what do you make of the argument that this introductory material, the we will find you have an extreme limitation, that if someone meets the listing, this seems to be saying, then the agency will automatically find that there's an extreme limitation because they meet the listing. But if someone doesn't meet the listing, then to equal it, they need to be able to show an extreme limitation that's equal. That this extreme limitation comes into play when you're trying to show medical equivalence. What do you make of that argument?
Well, Your Honor, I think that the introductory text to Chapter 14 are they're there to provide context with respect to when you are meeting the listing and you have ankylosing spondylitis, not when you are equaling the listing. But you can equal the listing if you don't have that medical impairment, that ankylosing spondylitis, but you otherwise meet all the other elements of the listing as it appears, and that's per 20 CFR 404.1526B2. And my client meets all of those impairments. And I see my time is up.
Can I ask one more question with Judge King's indulgence?
Of course.
Go right ahead.
Thank you. Is ankylosing spondylitis, is that a forward fixed impairment?
It is, Your Honor. It's forward. It's your spine being forward fixated, just stuck in that forward position. You're hunched over, and my client, her spine was fixated to the side, and she was hunched over to the side, which is also no picnic, unfortunately.
Right. Very absolutely. Thank you.
Thank you, Your Honor. Thank you, everyone.
Thank you very much. Thank you very much, sir. If we were in Richmond, we'd come down and shake hands with you and tell you we appreciated your arguments, so we're going to tell you that anyway. But it's good to have you with us. Madam Clerk, unless Judge Mr. Howard?
Yes, good afternoon, Your Honor.
Good to have you with us, Mr. Howard.
Thank you, sir. It's a pleasure to be here. Judge King, Judge Rushing, and Judge Harris, may it please the court, the appellants come before you seeking a ruling that the district court erred in withholding a finding of civil contempt against the Virginia Department of Corrections for its substantial failure to meet obligations it voluntarily assumed under a settlement agreement, requiring the department to significantly improve the quality and quantity of medical care provided to prisoners incarcerated at the Fluvanna Correctional Center for Women. Although the district court was persuaded that the appellants had satisfied the elements by clear and convincing evidence necessary to establish a basis for a finding of civil contempt, the court held that it was bound by decisions previously rendered by this court, holding that compliance with the requirements of Rule 65D of the Federal Rules of Civil Procedure is mandatory, and that the final order entered by the district court in this matter in February of 2016 that referenced but did not incorporate all of the terms and conditions of the settlement agreement was inadequate to satisfy the requirements of Rule 65D. There is no question here that the final order did not, in fact, satisfy the requirements of Rule 65D, which contemplates that an injunctive order, that all of its terms and conditions will in effect be reflected on the face of the document that also constitutes the order pursuant to which that injunctive order becomes legally effective. We nevertheless contend, for a number of reasons, ordered the should have found civil contempt on the basis of the evidence establishing its violations of the settlement agreement, and that it is not precluded by this court's prior precedent from doing so.
Does it still matter? Because as I understand it, the district court ultimately entered a new injunction, and I guess can enforce this one by civil contempt. Tell me what it is you want to do. Assume we send this back to the district court and say you were wrong, the 65 objection was forfeitable. So now what happens now?
Yes, Your Honor. So the settlement agreement contemplates a sequence of events pursuant to which the VDOC will bring itself into compliance with the agreement's terms, and that, as confirmed by the monitoring of a appointed monitor, that once compliance has fully been achieved, that the for a year after it has been reached, that the settlement agreement will go out of effect. Where we are is that the VDOC continues to try to effect full compliance with the settlement agreement. And so, although the district court did enter a separate and new injunctive order with respect to those elements of the settlement agreement that it found had been violated, those are a small subset of the total number of obligations that VDOC assumed under the settlement agreement. So if the court were to determine that VDOC's opportunity to rely on strict compliance with Rule 65D had been forfeited or waived, then in the continuing proceedings that are ongoing in the district court, we, the appellants, would have the opportunity, if and when necessary, to assert noncompliance and to seek a ruling with regard to civil contempt that, as of now, we are barred from seeking.
Why couldn't you do that as to the new injunction? You could ask for contempt of the new injunction, couldn't you?
Yes, Judge King, we could, but the new injunction is merely a reflection of the district court's determination after the 1 week trial in the enforcement phase that
sounds to me like you. Yeah, I thought you. I thought you won here, and it seemed to me like reading this, we had a loser. That we had a winner appealing, and losers are the ones that appeal. I mean, I thought you won the thing. You got another injunction. And
well, Your Honor, we won and we didn't win because
right to win and write the thing up as well, but the judge gets to write it up. He ruled in your favor, I thought.
Judge Moon certainly ruled in our favor with regard to certain aspects of our claims in the enforcement phase, Your Honor, but that injunctive order is not comprehensive to the same extent as the full settlement agreement. And the parties agreed in reaching the settlement agreement that all aspects of the obligations assumed by VDOC would be enforced, and they would be enforced by way of contempt proceedings if they failed to honor their obligations. And so there are obligations in the settlement agreement that are outside the scope of the injunction that was entered after the enforcement proceeding.
Counsel, it's Judge Harris. Just to clarify that point, I thought that the ones the judge put in the new injunction were the ones where VDOC was out of compliance. And so I had kind of assumed that the ones he didn't put in to the new injunction were ones where VDOC in fact was in compliance. So why doesn't that kind of take care of the problem?
It doesn't take care of the problem, Your Honor, because essentially at the enforcement phase, at the stage at which we went through the enforcement phase trial, that's effectively a snapshot, a point in time at which the court concluded that there was non-compliance in certain respects, and that there was compliance in some respects, and according to the compliance monitor, there was partial compliance in some respects. So the fact that as of the date of Judge Moon's ruling, his findings of fact and conclusions of law on the basis of the evidence produced or presented during the enforcement phase trial, that as of January of 2019, that he was not persuaded as to certain aspects of the things that we said they were not in compliance about, that doesn't mean that the next day they weren't out of compliance.
Okay. I got it.
in any event, it is our position that the appellees fail to invoke noncompliance with Rule 65D in a timely manner, that this court's decisions holding that compliance with Rule 65D is mandatory are distinguishable, and that the policies of due process and fair notice underlying the requirements of Rule 65D and supporting its strict enforcement would not be offended or contravened by a ruling of waiver or forfeiture here, because of the full and complete and comprehensive involvement of VDOC in negotiating and implementing the settlement agreement, such that they were well aware of what their obligations were and the fact that those obligations were enforceable by way of contempt. That being true, it's our position that if they felt that the failure of the final order to strictly comply with Rule 65D was a problem, they could have and arguably should have brought a direct appeal from the entry of that final order. They did not do so.
Counsel, what do you mean by arguably? I mean, is it your position that VDOC forfeited this argument in 2016 when it didn't appeal the order?
We certainly think, Your Honor, that under the analysis adopted by the courts in the decisions we've cited in our opening brief, I believe at pages 22 and 23 and maybe 25 and 26, holding that where a party has a problem with a failure of a court's order to comply with 65D, it should be brought in the context of a direct appeal. And they did not do that.
So that's a yes. So that's your position.
That's a yes.
The district court identified sort of two different times when in the district court's view, and I don't want to say it was a holding because he also thought it had been, didn't think you could forfeit, but the district court seems to have thought that if it were forfeitable, it had been forfeited twice. Once when no direct appeal was taken, and then also for failure to raise it timely in the contempt proceedings. And so I just wanted to get from you, do you think, do you think both of those are right? That you really have to raise it on appeal, not just in a timely way in the contempt proceedings themselves?
We do, Your Honor. We believe that the case law supports the proposition that in the absence of direct appeal challenging the deficiency of an order on 65D grounds, that argument is waived and may not be brought in the context of a collateral attack. We also agree that as a matter of fact, that there were numerous instances in which the defendants could have raised 65D prior to the time that they did, and they failed to do so in every instance until their post-trial brief following the enforcement phase trial.
Counsel,
They have, I'm sorry, yes.
This is Judge Rushing. Why does Rule 65 apply at all to the February 5th order approving the settlement agreement?
It applies, Your
It
Honor,
doesn't appear
because,
to me to,
I'm sorry, go ahead.
it doesn't appear to me to compel anything. The order approves the settlement, awards attorney's fees, and retains jurisdiction, but the order itself doesn't appear to compel anything.
Your Honor, the settlement agreement is in the nature of an injunctive order, and I believe that the appellees have conceded that fact in their post-trial brief. It clearly imposes numerous affirmative obligations that the VDOC was obligated to meet, and the final order itself, while not setting forth the terms and conditions of the settlement agreement or even incorporating them by reference, nevertheless reflects that the settlement agreement is decreed implemented, and therefore in the absence of a conclusion that the settlement agreement was in fact in the nature of an injunctive order, 65D wouldn't apply at all.
Right. Well, that's the difference, right? That's the difference between a settlement agreement where the parties come to an agreement that they're both going to do certain things. That's the difference between that and an injunctive order. An injunctive order is where the judge orders someone to do certain things. And it doesn't look to me like the February 5th, 2016 order is an injunctive order.
Your Honor, we
So
certainly
Rule
believe,
65 wouldn't apply at all.
Your Honor, we certainly believe that the settlement agreement was intended to and perceived by both parties to contemplate injunctive relief, and that
Does it say that? Does the settlement agreement say it's going to be, that it is an injunction?
the settlement agreement is not itself characterized as an injunctive order, Your Honor.
Yeah, but 65D, as Judge Rushing says, deals with the scope of every injunction. And the restraining order, well, it's not a restraining order. Restraining order is an interim thing under Rule 65. You got it. I think you're stuck with whether it's an injunction or not. And it doesn't call itself an injunction. And the order that approved it didn't call it an injunction. Did it?
It did not, Your Honor.
Okay. Well, if it's not an injunction, where does that leave this thing?
It's a little hard to tell, Your Honor.
If it's not an injunction, are you out of court? Or then
If it's not an injunction, we're not out of court. Certainly, I think there's no challenge to the proposition that the district court was entitled to enforce the settlement agreement as a contract, even if it did not have the power to enforce it by way of civil contempt.
yeah, but you're back to where I was to begin with. I thought you won. The Judge Moon ruled in your favor.
Well, Your Honor, he did, but he did not rule with regard to the remedy that was the premise upon which we brought the motion for order to show cause.
Counsel, can I ask you, I know the settlement order doesn't say it's an injunction. Does the settlement order expressly say that it will be enforced by contempt?
It does, Your Honor.
Settlement order?
I thought an injunction.
Where does it say that?
Sorry.
Yeah, counsel, could you point me to where it says that?
Yes, ma'am. I'm finding it. Bear with me for half a sec. Sorry, Your Honor. I believe it's section 4 of the settlement agreement, or section 5. I'm sorry.
Agreement. That's the settlement agreement. That's not the court's order.
Oh, I'm sorry. I thought that you would ask me about the agreement.
No, I had asked about the settlement agreement. That's how this got confused. I just wanted to know if the settlement agreement provides for that. Yeah. So the settlement agreement provides that it's going to be enforced by contempt.
Yes, Your Honor.
Okay.
And then
so it sort of seems like maybe the parties thought this was going to be an injunction, but maybe it wasn't. Is that what's going on here?
Your Honor, I think it could be, I think on the basis of the record, it could be construed that both sides believed that this was in the nature of an injunctive order and that it would be enforced by contempt, and that the final order makes reference to preservation of the district court's jurisdiction for purposes of enforcing the agreement in accordance with its terms, which of course contemplated contempt.
But the judge who had signed the order that is Judge Moon in this case, would understand the order necessarily better than 3 appellate judges. It was his order.
That's correct, Your Honor, and I don't think that.
And you want us to say that he didn't understand his order?
No, sir.
And that we understand it better than he did?
No, sir. That's not our position at all. Our position is that he well understood what the provisions of the settlement agreement contemplated and what he meant when he signed the final order saying that he was retaining jurisdiction for purposes of enforcing the agreement in accordance with its terms. He did not rule that he was not empowered to grant an order of civil contempt because he didn't think that the settlement agreement contemplated that. He ruled strictly on the basis of the fact that he felt that there was binding precedent in this court saying that Rule 65D compliance is mandatory and without exception.
Counsel, it's Judge Harris. He also said twice that this wasn't a consent decree. And that made me think he thought this wasn't an injunction, because I think a consent decree is just a settlement plus an injunction. And if he's saying it's not a consent decree, doesn't that mean that actually he does not understand this order to be an injunction?
I don't believe so, Your Honor. I believe that he was really referencing the fact that consent decrees do involve certain magic words, and that this settlement agreement did not contain those magic words.
Mr. Howard, I think your time's expired.
Yes, I'm well over my time. Thank you, Your Honor.
Okay, but you have some rebuttal time as well. But let's see what Mr. Schnetzler, you're going to explain this to us?
Yes, Your Honor. Thank you. May it please the court. Nathan Schnetzler on behalf of the appellees that I'll refer to as the VDOC, as they were referred to during the opening argument. Judge King, Judge Harris, Judge Rushing, I think you all have hit the nail on the head from the get-go during the opening argument, and the fact that this was in no way, shape, or form an injunction, the 2016 final judgment.
But you're the one who went to court and said this is in the nature of an injunction and it violates Rule 65D, which governs injunctions. So when did you have this epiphany?
Your Honor, the VDOC raised the issue of whether or not this was an enforceable order through contempt in their response to the motion to show cause. Obviously, the motion to show cause for contempt is not in the nature of an independent cause of action where, for instance, Rule 8 or Rule 12 would apply, where a party needs to assert or file a responsive pleading. And so the only response that the VDOC was permitted to submit was its motion to dismiss, where it did raise the question of whether or not this was an enforceable decree from the court that would be enforceable through the court's contempt authority.
But you took the position it was an injunction, and they failed to comply with Rule 65D. Is that right?
No, Your Honor. We took the position that this was not an injunction because it did not comply with Rule 65D. You
said it was in the nature of an injunction, which is why it had to comply with Rule 65D in the first place. I know it's a little circular, but
Your Honor,
that was your position, right?
Your Honor, we stated in a post-trial brief that the parameters set forth in the settlement agreement are injunctive in nature. We never conceded that the settlement agreement itself was an injunction, mainly in the sense that the settlement agreement only assesses prospective relief, equitable relief. There was no sort of monetary aspect to the settlement agreement. We certainly did not concede it was an injunction because, again, it didn't. The court's order is the only aspect of what can actually make an injunction. The parties cannot confer contempt authority on the court unless the court speaks through its order and specifically compels a party to do something through its order, which the order approving the settlement agreement in this case was an order pursuant to Rule 23. Because this was a class action, the parties couldn't engage in a private settlement agreement and walk away from the case. The court had to approve that the settlement agreement was fair and adequate and reasonable to the class. And so that's what this order was. This was a Rule 23 class action settlement agreement approval order. The court never did any analysis with respect to whether or not it was appropriate to issue an injunction. As of course, the court's well aware, there are several factors that the district court needs to assess before it can even issue an injunction. And the court never did any of that analysis when it issued its findings of fact and conclusions of law in 2016. So this was purely a Rule 23 settlement approval. And the court's order is very clear. And I think it was, I can't remember if it's Judge Harris or Judge Rushing commented that the court did twice make clear that the 2016 final order was not a consent decree. And the court was clear in its opinions on the motion to reconsider and in its findings of fact and conclusions in law after the enforcement proceeding, that this was a consent decree is both an injunction and a settlement agreement, and the 2016 order was not that. And it's really clear from the face of the order that it isn't, because the judgment order from 2016, it doesn't reference a single term of the settlement agreement. It doesn't reference the settlement agreement's docket entry. It didn't attach a copy of the settlement agreement. It didn't incorporate any language by reference. As Judge Rushing pointed out, the 2016 order didn't direct VDOC to do anything. It didn't compel VDOC to do anything. And even as we've discussed in our brief, as the court did in the D. Patrick case out of the Seventh Circuit, Judge Moon's 2016 order didn't even state that it was retaining jurisdiction to enforce the settlement agreement through contempt. It said it was retaining jurisdiction to enforce the settlement agreement, but it did not include the language in the order that it was retaining jurisdiction to enforce it through contempt. And so there are a whole host of reasons that this never even was intended by the district court, and we believe the district court disclaimed twice that the 2016 order was an injunction that would be enforceable through contempt. And Your Honors, as we noted on brief, Judge Posner was clear in the Chicago Northwest case out of the Seventh Circuit that district courts have a duty to assure that their injunctions are proper. And we think that it's clear that, as Judge King referenced, Judge Moon understood his order better than any of us. It came from his chambers.
But counsel, it's Judge Harris again. I'm sorry to interrupt. So I find this case sort of genuinely baffling because, yes, the district court would understand the order best. And on the one hand, the district court appears not to have thought it was an injunction. But on the other hand, the district court sure spent a lot of time discussing whether or not a Rule 65D objection could be forfeited, which would all be irrelevant if this isn't an injunction. Why didn't he just say, I don't know what you people are talking about, Rule 65, this isn't an injunction?
And I'm not sure either, Your Honor, other than that the plaintiffs obviously in their post-trial response brief to the VDOC's brief did contend that that VDOC waived or forfeited this argument that the 2016.
Well, because you raised you came into court and said this doesn't comply with the rule for injunctions. They said you forfeited that objection, and the district court did not say this is all beside the point because there's no injunction. The district court went through an elaborate analysis about whether or not a rule that applies only to injunctions could be forfeited. So I am left really at sea as to what the district court intended here. And I guess what would you say, what would you advise me is the most important thing I should look at to figure out what the district court thought this order was?
I think the most important thing that what the district court thought this was that it did not qualify as an injunction under Rule 65D as it held because.
But you didn't ask him to make such a finding, did you?
Well, we asked the court to conclude that it couldn't.
So answer my question first. Did you ever specifically say, Judge Moon, this is not an injunction. You need to find it's not an injunction. And Rule 65D, Rule 65 has no application to it for anything we're doing.
Judge King, we framed it as, I don't think exactly.
Did you ever frame that?
We asked the court to decide that this was not an injunction because it did not comply with Federal Rule of Civil Procedure 65.
Right. But so this just seems a little bit circular. If your answer is, if an injunction violates Rule 65D, that's how you know it's not an injunction? Is that?
No, Judge Harris, it's more that if an order doesn't comply with Rule 65D, it does not qualify as an injunctive order, if that clarifies.
Okay, so the thing that makes this not an injunction is that it violates Rule 65. So if we think that the district court was wrong and you can forfeit a Rule 65 objection, then is there an injunction again? Because now Rule 65 and the violation of Rule 65 is off the table. So now is it an injunction? Let me ask it to you this way. What if it was the exact same order, but it said, I'm retaining jurisdiction to enforce the settlement, which requires that VDOC, and then cut and pasted the settlement agreement right into there? Now is it an injunction? Because now it complies with Rule 65 if it is an injunction.
Correct, Your Honor. That's absolutely correct. It would be an injunction under those circumstances that
it would. Okay, even though it wasn't called an injunction. Okay. Okay, so the thing that makes this, in your view, not an injunction is pure and simple the Rule 65 error, and if that were cured, it would be an injunction. Okay.
Yes, Your Honor, the order would be an injunction if it complied with the requirements of Rule 65 and this court's interpretation of Rule 65D, requiring strict adherence to that the court must specifically state what it is enjoining the party from or to do in its order. Correct.
All right, and then let me just, one last question and I'll stop. Assuming hypothetically, and I know you disagree with this, but assuming hypothetically that a Rule 65 objection can be forfeited and was forfeited here, that makes it an injunction, right?
No, Your Honor, it doesn't make it an injunction any more than if a party fails to raise a statute of limitations defense means a case was brought timely. It just means that defense, it can't be a bar to the claim.
Well, I don't, it's the Rule 65 error that makes it not an injunction. And even if the Rule 65 error is forfeited, it's still not an injunction.
Correct, Your Honor. Just like I said, just as if a party fails to assert an affirmative defense, it doesn't mean that that defense the party has precluded from arguing that it doesn't comply with the statute, with the rule, and raising that argument. So just like as if we had never raised it until on appeal in the first instance. But I think that's why the Fourth Circuit has interpreted the rule so strictly, is because of what we're wrestling with this afternoon, is that Rule 65D is very clear in what it requires for an order to be considered a proper injunction. And this order did not qualify. So, Your Honor, moving forward, I know that so since we've been talking about the issue of whether or not there was forfeiture or whether or not it can be waived, again, as we stated earlier, the district court, we believe, sort of took a mistaken approach in suggesting that the appeal should have been an appeal should have been noted back in 2016, because again, the only issue before the court in 2016 was whether the class action settlement should be approved or not. And we believe that the D. Patrick case versus Ford Motor Company really shows this premise applies because in the D. Patrick case, there was a settlement agreement. The parties there stipulated that the court would retain jurisdiction to enforce it through contempt. The district court's order in that case said that it was retaining jurisdiction for the purposes of the enforcement of the settlement agreement and subject to the contempt powers of that court. And there was no appeal initially when the district court entered that order dismissing the case with prejudice. And 12 years later, contempt proceedings were brought for a purported violation of that settlement agreement. And there was no issue as to whether or not that there was neither the parties nor the court raised a question as to whether or not the purported contemner should have appealed the original order 12 years prior for not complying with Rule 65D. The court concluded there that it was not an actual injunction because it did not contain the actual language compelling the parties to actually do something or refrain from doing something. And contrary to what the appellants have contended on brief in their reply brief, the Seventh Circuit has not abandoned that position. And so it's essentially that the litigants don't get to confer contempt power on a federal district judge over private agreements. It's the district judge who has the authority to enforce his orders so long as they comply in terms of an injunction, so long as they comply with Rule 65D. So, and Your Honors, the Fourth Circuit, again, as we've noted on brief, has time and time again taken a strict compliance view, in all the way going back to Alberti, to Thomas versus Brock, CPC International, and Patry versus Delia. The court's been unwavering. The Rule 65D's requirements are mandatory. This order did not comply. And even if the court were to consider overturning its prior precedent, the circumstances here do not warrant it because the question of whether or not VDOC forfeited this argument or this objection, however we want to phrase it, doesn't hold water based according to how the district court and the appellants would like to frame it. Because again, as I noted earlier, this isn't a typical independent cause of action where a party is asserting in a responsive pleading affirmative defenses, and there was no scheduling order about when to file any sort of answer. It was simply a motion to show cause, followed shortly thereafter by a request to dismiss the motion to show cause. And the court didn't even rule on whether or not the plaintiffs had met their prima facie case with respect to the show cause motion until the parties got to trial. And it was at trial prior to when the case had been submitted to the court for decision that the court asked the parties to submit proposed findings of fact, conclusions of law. And so before this case was submitted for decision, even if the court doesn't consider, for the sake of argument, that it was properly raised in the motion to dismiss that was filed in response to the show cause, it was certainly submitted to the court before decision. The whole purpose of forfeiture is to preclude a party from raising an argument where the district court and the opposing party didn't have the opportunity to respond to it in the first instance. And that absolutely occurred here. Both the district court and the opposing parties in this case had an opportunity to address the Rule 65D compliance argument before it was submitted for decision. It was addressed again on a motion to reconsider under Rule 59. And so it was adequately asserted and timely asserted in the district court, we would submit. And so even under those circumstances, there's not a basis for finding forfeiture under the facts of this case. And finally, in closing, as Judge King noted at the beginning of the opening argument, the plaintiffs are not without a remedy in this case. The class is not without a remedy. The court felt perfectly, district court felt perfectly comfortable ordering specific performance accompanied by an injunction. After the enforcement phase trial, it can certainly enter any other injunction it believes is appropriate and the circumstances warrant. And I think it speaks volumes that the district court has now twice refused to enter that settlement agreement as an actual order in full signed by the court. That the settlement agreement was initially presented to the judge with an endorsement line for Judge Moon. He did not sign that settlement agreement, and when the class asked Judge Moon to enter it as an order at the conclusion of the enforcement phase, he again declined to do so. So we believe that there's the class is not without some sort of remedy for enforcement of the provisions of the settlement agreement, as Judge Moon has made clear below. And for all these reasons, Your Honors, unless you have any further questions, we would respectfully request that the order of the district court be affirmed.
Thank you, Mr. Netzler. We appreciate it. Mr. Howard, you've got some rebuttal time.
Thank you, Judge King. A couple of things. First of all, although I have to infer from the sincerity with which my opposing counsel keeps repeating the proposition that they raised the Rule 65D noncompliance issue in their opposition to our motion for order to show cause, they did not. And not only did they not do it, but the district court expressly found that they didn't do it. So with all respect, that's a misrepresentation. And it's doubly troubling because it's not only not true, but even if it was true and the district court made a mistake in saying that it wasn't true, they would be obligated to candidly and forthrightly address the district court's finding and say why it was wrong. And they didn't either. Instead, they have made this falsehood that they raised this defense in their opposition to our motion for order to show cause a centerpiece of their position in this appeal. And I think it's very troubling that they have done so. Secondly, there was no waiver issue presented in any of the Fourth Circuit decisions that addressing Rule 65D compliance that preceded this case. In each instance, as we pointed out in our briefing, the challenge on the basis of noncompliance with Rule 65D was made on direct appeal. And therefore, although those cases certainly say what they say, and Judge Moon clearly regarded himself as bound by them, we submit that all of those cases are distinguishable in the sense that there was no direct appeal here in which Rule 65D noncompliance was the basis for the challenge. Judge Harris, did you have a?
Oh, no, I'm sorry. No, sorry.
Okay. And so what we are left with is a situation in which, and I agree with my counterpart, that we did in fact ask the district court at the conclusion of the enforcement phase proceedings to help us eliminate this problem going forward by simply incorporating all of the terms and conditions of the settlement agreement into a new injunctive order. And Judge Moon declined to do that. He didn't explain why he declined to do that. And I think it's speculation to assume that it was because he didn't regard the settlement agreement as injunctive in nature. I think it's equally plausible that he felt that this court would either find that the 65D noncompliance issue was waived, in which case the settlement agreement would effectively take on the aspects of an injunctive order, or the court would adhere to its prior precedent, in which case there was no reason for him to take that step. But I do believe that the court is clearly in a position to find, as did the district court, that by waiting until filing their post-trial motion after months of discovery, a week of trial with regard to issues that would have been unnecessary if the motion to show cause that the VDOC should be held in contempt was barred from the get-go. And so it is significant that they waited until as late as they did to raise the 65D compliance argument. And with that, unless the court has any further questions, I yield the remainder of my time.
Thank you, Mr. Howard. We'll take, well, I'll first say I appreciate we appreciate counsel's fine arguments in this case and your assistance to us. We'll take your case under advisement. If we were in Richmond, we'd come down and shake hands with you and say that to you in person. Maybe next year you'll be back and we'll all be able to get together. And Madam Clerk, we will adjourn court until tomorrow. And the court will go into conference.
Thank you very much, Your Honor.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.